What is up? What is up, chat? How's everybody doing tonight? We are. There he is.
There he is.
I got two of our special guests. So sadly, looks like number four may not make it. He had a lot of stuff going on. Matt may possibly pop in. Don't know for sure, but he told us not to hold our breath. So I hate that he's not able to be here. But we'll catch him next time. We're gonna start doing Fridays with Matt too. So. Anyway, yeah. I got Greg, everybody's favorite attorney, and
my beard's coming back. By the way, I had to let my face breathe for a second. The backbone.
Yeah, he had to unleash the ugly for a minute. I'm just kidding. Look, I gotta have one
right,
too.
That's right. No,
I'm hiding ugly too. And then we got man, I just drew a blank. The ecological criminal report. We have him back. I'm sure y'all remember it was a pretty popular show whenever we did a live a few weeks ago. That was great. And so yeah, we're going to talk about this hearing and a little bit of anything else that comes to mind. So you know how these conversations like to go. Anyway, all right. Greg, you want to say anything? Anybody want to say anything before I fire up this video? We got a Fox News clip I figured we'd play and comment on. It's just kind of just a summary of what happened today. So we can play that and then.
No, I'm good. I mean, I think we just get right into it. Unless in ecological, what's your name?
I'm just going by Eco here.
Okay, cool deal.
But yeah, no, it was a fun day today, sort of checking out what's going on. It looks like the thing's going to be delayed. The preliminary hearing's going to be delayed by a month and a half, maybe. And, so cameras haven't been kicked out of the court yet. So
thank God.
We got a little bit of transparency. And then anybody who's been checking out this docket can see all the...
we definitely need to talk about that.
All of the exhibits that are going to be shared, whether they're going to be shared with us or not is another question.
Right.
But we'll see what happens.
Yeah, we'll play a little bit of this, and then I thought about pulling that up. But if you have that docket in front of you, we can just go over it that way. I mean, we don't necessarily have to show it. You know what I mean? But sure. There's definitely some interesting things on there, and even more interesting some of the things that are not on there. So. Anyway, let me, I'll hit the go button. We'll watch a few minutes of this and then we'll get into it. All right. Fire in the hole, guys. Here we go.
Let's head out to Utah right now where the hearing involving Tyler Robinson is ongoing. Let's head out to that live here on Live Now from Fox.
Request. The defendant's request for a categorical finding that the presumption of electronic media coverage has been overcome is respectfully denied. The court must make the appropriate findings on a request-by-request basis. Unless otherwise ordered by the court, Rule 4-401.013a requires news reporters to file an electronic media request at least one business day before the court proceeding. 1 business day is insufficient time for the parties to object to electronic media coverage or for the court to weigh the appropriate factors and issue a decision. Therefore, the court enters the following. This is the standing order on electronic media coverage. News reporters are required to file requests for electronic media coverage of court proceedings at least 14 days before the scheduled proceeding. The request must be consistent with all other provisions of Rule 4-401.01. Any request that is filed later than 14 days before the proceeding may be similarly denied. All requests will be filed in the docket. If a party seeks to suspend or restrict electronic media coverage of a court proceeding, the party must file a motion under Rule 4-401.01 no later than 10 days before the proceeding. The motion must address the particular circumstances of the proceeding and be no more than 4 pages in length. The opposing party may respond to the motion.
So if I'm understanding what he's saying correctly, basically they're not banned, but they have to request to use them every time. They're not just he didn't okay to just come in there default, every at every hearing or what have you. They're not banned, but they do have to get permission before they do it each time.
I like it. Here's one thing I'll say is that, after the initial issues with like the lip reader and body language people, if you notice, I think Judge made it to where y'all just need to focus on the lectern. and on me. And I think that's been great. I mean, I really think that that is a good fix. But I'll say another thing is that obviously the offenders, Newsmax, I think Fox News is actually an offender too with the lip reading and stuff. You know, obviously Judge knows that. And so I think doing the applications will give him a good chance to weed out maybe the people who are prior offenders and or make sure that those people who offended realize that, like, hey, we need to tighten up and not be doing what we were doing.
Yeah, I got you. So I wonder if that's what that means. Does that mean for each media organization? Because before, anyway, wasn't it like just one of the outlets had cameras in the rooms and then the rest of them basically were just piggybacking off of that? Isn't that the way they're doing it, or is that not the way they're doing it now?
I think it was pretty much open season when they first started, but again, after the offenses, I think that standing order's been getting more and more strict until we see what we have now.
Yeah. You know any more about it, Echo?
The only thing I would say is it seemed to me that the sort of claim was that it would violate some rights, and I'm not a lawyer, so I don't know. This is kind of how I'm interpreting it, but it would be either unconstitutional or violate rights to kind of do a blanket categorical denial. And so rather, because the claim was that it would certain exhibits would be potentially creating prejudice. The effects of past issues had already created prejudice. And so rather than kind of take that for granted, because it was also in these arguments that were happening, it was sort of claimed that it wasn't because of the camera or the video in the court that was the problem. It was rather the commentary that had been going on.
Right.
And so you can't necessarily bar that or even control that, because that's free speech. And so the argument was, well, providing access to this video would be, setting up for that prejudice. But the court is sort of trying to weigh that or balance that need of the rights of the defendant with the public interest.
The rights of the public too. Yeah, I mean,
yeah.
So that's why you can't sort of say, give that blanket ban, but now you have to do every single time. And so now what they basically said is 15 days before this happens, the media has to sort of put in a request, followed by, 10 days later or 7 days later, then the defense can sort of respond, and then so that's going to happen every single time now. And so we're already and Greg, let me know what your thoughts are. But I've never seen a docket with 530 different documents that had even come in before the plea or before any sort of preliminary trial had even come in. So I don't know if that's normal or what we're doing here, but expect even more because of that rule.
Yeah, well, you hit the nail on the head, Echo. It's obviously Tyler Robinson's right to a fair trial, which his attorneys are obviously representing him on, and then the public's First Amendment right to open proceedings, which the judge, is the public's advocate on that right. And so he has to obviously balance those two things, and we could go and debate all day which one's more important, but I do like the direction that judge is taking it. I thought that, the lip reading, body language stuff was way out there for me.
Yeah, and I don't need any of that. You know what I mean? I don't need any of that. Cutting that out is not hurting my feelings at all.
I mean,
that's what bothered me before was the fact that, because I know it was originally, it was like one outlet that had cameras in there, and then everybody else was basically piggybacking off of them. And what I always said is, look, this one cameraman has all of our fake when it comes to seeing this in his hands. I mean, all he's got to do is violate, make another violation, and all of a sudden we're kicked out. It's not like just the one outlet's not there. But now if multiple outlets are going to be able to be in there and have to, apply, then they can let the ones come in that haven't, transgressed, and the ones that have, they can keep out. So,
That's why I like
there's
the
nothing wrong with that.
application. Yeah, that's why I like the application part of it. I think it's going to give judge some leeway to hold those people who are the offenders potentially accountable in some way, at the same time, but also encourage them to tighten up. Let me say this, I've spent a few days in county jail before, just putting it out there. And, when I see someone come to court and they're smiling because they're not in county jail for a day, that means nothing to me. You know what I mean? Of course, I like to see people smile. So when they were doing that whole thing, like, oh, he must have no remorse because he's smiling, like,
Right.
it was too much for me. And Echo on the docket thing. So yeah, in civil cases, particularly in federal court, you can have thousands of filings, right? But that's usually when there's multiple parties. In this case, I think one of the reasons why there's an inordinate amount of filings, and by the way, their digital system's terrible, is because we have the media entities who are also in this, right? And that's been a substantial battle. And so entering in those couple extra parties for the media has probably beefed it up by a third,
Yeah.
But I do consider it not normal for that many filings in a criminal case, just in my
Right.
Yeah. Even a death penalty case?
as far as I'm aware. And again, I think it's because of the media battle.
Yeah. Yeah. Because a lot of that is on behalf of the media, correct?
Well, and it's just a very dense, in some ways complex case, that's obviously huge. Everybody's talking about it. And so I think that also too adds, obviously, as we've seen, to the number of filings, objecting to the media, why they did the January 9th motion private, because of the media. It's caused a lot of extra motions and issues, obviously.
Cool.
All right. Hey, I sped him up a little bit. Can you believe I already had him at 1.25 speed? Sorry, I wasn't trying to cut you off.
No, Adam, can I just ask? I'm seeing the recording hasn't started. I don't know if that's true or what.
So
That's on the
yeah,
right.
that is true. I didn't realize it till last minute that my StreamYard is full. So
Gotcha.
I could still
wonder if I
download
can
it because
record it. Am I able to record it?
you could at least do a screen record. What I do, I've had that happen before, is I just go and download it from YouTube Premium, because you can download, and if I need
It's not going to let me
post it
record. I'll
somewhere
do a
else.
screen record just for
There you go. Yep.
SMD of it.
I didn't think about just doing a screen record also at the beginning, but yeah, that'll be good. That way, if we need it, we got it. All right. Well, I sped him up a little bit. Like I said, he was already at 1.25, which is funny to me because that still seemed awful slow. But I sped him up a little bit. We'll listen to a little bit more and see if there's any other nuggets in here.
Okay.
No later than 5 days before the
Oh, well, never mind. Let me back that down just a little bit.
response is limited to no more than 4 pages in length. Any reply must be filed no later than 3 days before the hearing. The reply is limited to 3 pages in length. No oral argument on the motion will be held. The court will issue an order before the proceeding, and if the request is denied, issue particularized findings denying the request. The evidence presented at the April 17th, 2026 hearing and all arguments already in the record are preserved. This is the order of the court. This concludes the reading of the second ruling of this court.
All right.
All right, counsel, what I want to turn to next is addressing the outstanding motions. As we are vacating the preliminary hearing, which is set for, I believe it's May 18th, the week of May 18th, that frees up time to address outstanding motions. And the court wishes to make best use of the time as you were previously scheduled to be there. So I'll turn to the parties to hear from you in determining.
Since you got to listen to the whole thing, is there anything much else besides the fact that they're continuing it? I mean, the main thing was probably the media part, I'm assuming.
So basically, one of the things that came up was that Ballard was accused of improperly violating the what we're calling the gag order. And so that was basically saying that you couldn't make any extrajudicial comments. And so when that Daily Mail article came out, and I think Daily Mail is in on it, as is New York Post, but whatever.
As always.
As always, right? But so there's a question of whether the prosecution is colluding with the media in order to sort of create the optics that would prejudice their client. And so when the Daily Mail came out and basically said that, reporting on what the defense lawyers were saying with regards to this ATF report being inconclusive.
Oh yeah, I remember hearing about that.
The prosecution basically went out to Daily Mail, I think, and New York Post, and just tried to correct the record. And so the claim was that in correcting the record, they basically made statements that they shouldn't have, and as a result should be not only in contempt, but the judge should grant their motion to, I guess, deliver to the defense all of the communications that the prosecution had made to all of these media entities to see the nature of what that had happened. And so
that's fair.
All right, that's fair, right? And then the prosecution basically said, oh, we didn't do that. All we said was, the defense had left out that, the gun couldn't be excluded. They said that the defense said that
I think what they had said was because it was inconclusive, that meant that they could not tie it to the gun. And I think that the clarification is not only could it not be tied to the gun, it was also inconclusive that it wasn't the gun.
Right. So it couldn't be ruled out.
Right. Exactly.
Whereas the
semantics.
So the defense wasn't wrong, but what the prosecution said is that they lied by omission by saying that it couldn't be ruled out. And so when the Daily Mail said all of this stuff, reporting on what the defense had said, the prosecution was like, oh, the media is like getting this wrong, so we're going to go out and correct the record. And so that was the kind of issue that the defense had said was violating that record.
And so what did the judge end up doing on that one?
And so what the judge had basically said here was, well, since we continued, and so anyway, so what the prosecution, or sorry, what the defense, I think, had said was, we also need a few days in between the time that this gets ruled on and the time that the preliminary hearing has, in order to, one, figure out the that issue with regards to the contempt, but also we need to figure out, since all of this hearsay, which is inadmissible in the actual court, is going to be prejudicial for our client, we need to make sure that that is not going to be public. And so because they continued it, and because this date has sort of still remained open, I think they're trying to now set this date as the time for which all of that's going to get figured out. So I think that's what's happening.
It seems to me like they're concerned about the gun in the reports, because they haven't got any of the underlying data and stuff. How everything was collected and conducted. Go ahead, Greg. I know you got something to say.
Oh yeah, no. So yeah, I was gonna say that. Where was that? One thing I was going to say for sure is that this is really when we talk about the prosecution or state, or let's just say the government's, statements to the media, this case is very unique because you had the president, the governor, the attorney general of Utah come out like within a day or two and say, hey, more or less, this is a death penalty case, and then spoke almost directly that like he's guilty. And so just that alone leaves a residual stain upon this case that might have appeal written all over it for Tyler Robinson should it go south for him.
Yes,
But you know,
I see an appeal coming if for some reason, you know.
yeah, but you know, the media, you know, colluding with the prosecution. I mean, some of the stuff I've seen has just been so prejudicial that it's hard for me to imagine that like they actually like just did that on their own. To be quite
Right.
honest. Yeah,
And-
to be honest with you.
And just to throw this out here, I think it was basically saying that the prosecution connected with the New York Post to sort of handle this, and it's so far unclear how the New York Post got access to the picture of that gun. And so, whether the prosecution is sharing that with the media, the actual exhibits with the media, would seem to be, one of, I think, the questions that I would wonder. Whether the state is sort of behind the scenes feeding we figuring out, hey,
Surely
we
not.
want you to say this or that in
Mhm.
order to, on the one hand, prejudice the potential jury pool so that everybody kind of knows what, is definitely true. But on the other hand, with this Daily Mail, Daily Mail has not been kind to Tyler Robinson or Lance Twiggs. And so when this Daily Mail came out and said, oh, it's, potentially exculpatory or whatever, it prompted basically the prosecution being able to say, oh, look, media is favorable and prejudicial on behalf of Tyler Robinson. And so therefore, like, that argument that the media is prejudicial against him does not hold up because look at this one example.
Here's
So
what's here's what's
that's
crazy.
games,
Go ahead.
right? No, it's just games all around. So
Yeah, it's crazy because it's like, one article out of like 50,000, is like kind of favorable to the defense. But, the thing is that the defense didn't even come out and openly tell the public that, hey, this is what the report said, right? That's when I mentioned that January 9th motion, they filed it private.
Right.
And I agree with Barron. Like, I just don't see any reason why you would have done that with as bad as the media coverage has been for Tyler Robinson. That is most definitely a win in the media, right? To say that the ATF public, the ATF, the alcohol, tobacco, firearms, messiahs are unable to conclusively connect the bullet fragment with Tyler. I mean, to me, that's extremely exculpatory, especially when we consider the environment in the media that was occurring and is still occurring, today and then too.
Yeah. Can I also
Yep.
just sort of quote one thing?
Yeah.
And this is the prosecution's this is their opposition to the motion for an order to show cause for alleged contempt of court and for an order compelling discovery related to the alleged contempt. So, and I just thought this was ballsy, to say the least. But they introduced this by saying, the rules of professional conduct do not require lawyers to remain silent in the face of unduly prejudicial publicity. Instead, the rules expressly allow lawyers to set the record straight. And so I thought this was really interesting because it sort of allows people to read this to say, oh, darn, well, if that's the case, then why hasn't Tyler's lawyers been sort of correcting the record from the very beginning? Because clearly, if there was a record to correct, they should have done it according to this. Now, of course, there are ways to sort of think through this. Like, on the one hand, the defense may have, they've only got 4 people or whatever, and so they need to, handle the time that they have efficiently. On the other hand, they might have just gotten a mistake. They might have mistaken what the rules were here. On the other hand, they might be in on it and sort of stipulating to the prosecution's facts here, or just the general optics of this are fascinating. But I just thought that was a really interesting line that that was a little messed up, if I can say. But they got a posture, so
Yeah,
And,
no,
you
they
know-
have to take a stance. Go ahead.
I was going to say, and the defense keeps on about the cameras being in there and prejudicing people, whatever, making him. Anytime, it's like I've always said, you see somebody walk in orange, leg irons, whatever, it may not even, you may not even realize it subconsciously that does affect the way you view a person. And I get that. But as far as, actually seeing him in the courtroom, I mean, the defense acts like it's just a huge deal and that it's just really, really bad. But, I'm thinking that I don't think these defense lawyers have gone online. Like, have they not gone to the internet? Yes, I agree. There's still a huge chunk of people that just assume he did it. But I don't think they realize the amount of people, though, that don't think he did it.
I'll speak in their defense real quick. I mean, again, like I told Echo earlier, the lip readers, the body language. I mean,
Yeah.
it was so prejudicial, in my opinion, as an attorney.
Yeah.
And again, I haven't done just a ton of criminal defense, but I have done a bit. It's like, to me, it was so prejudicial that I give them some slack of kind of being gun shy at that point.
I wouldn't want that either. Now, that's like I said, that we don't need any of that.
Yeah.
Nobody needs that.
Yeah, no, I mean, and the thing is Tyler's a presentable young man. You know what I mean? Like, he looks fine and professional when he's got his suit on. So it's like there's
Got a
really
4.3 GPA.
Yeah, there's nothing wrong with him being on camera. It's just on the back end when you got these people who, just in my opinion, and we can put the tinfoil hat on a little bit, who are really working to solidify the narrative of his guilt.
Yeah.
I mean, it doesn't seem like they'll stop at anything, and they'll pull anybody that wants a little bit of fame, or I'll never forget. I think it was the body language expert that I think it was Fox News or Newsmax brought in. It's like, here he is saying basically that Tyler's body language insinuates that he's guilty and remorseless and all this.
They should have got Chase Hughes.
Black, you know what I mean? And then they had his YouTube handle right there, and so you can kind of see all that for what it's worth.
And the tie was supposed to symbolize like the trans teeth kind of.
See, all that opining should not be going on. I mean,
but it's so over the top. Right?
It is.
Like,
it really.
It's
is.
not even like. There's something going on.
Oh, they're doing it for a reason, no doubt. You know what I mean?
Well, and what that reason is kind of, is it in order to, have this be reversed on appeal and sort of go to the Supreme Court or something? Is it?
Is it to actually prejudice towards? Is it to actually prejudice Tyler against Tyler, or is it to get the cameras kicked out? I mean, like, you could look at this so many different ways.
And to that point, one of the interesting things is like, because you sort of like, and this sort of was litigated, I guess, in the early parts of the docket, but the cameras were needing to be removed, it was said, because they were showing the restraints, and that would create the prejudice that was more likely to get him found guilty. But the question was also why is he even wearing restraints in the first place? And he had to make a motion to wear civilian clothes as well.
Right.
And what it sort of came down to is like, and this is why certain parts of the court hearing at that time was sealed, and everybody had to sort of like leave the room, including his parents, because those assessment processes, as well as the sort of evidence upon which it was ruled that, or the assessment was made, all of that was prejudicial, and so therefore needed to be kind of off camera. But it all came down to, what was said in this conversation, like potentially with his parents, in which they said that he was suicidal, and so therefore needed to wear that like suicide vest in the
turtle
first place,
vest is what we call it.
which
Yep.
yeah, which then got him all of these pictures, etc. And so
That's the
we
first
don't-
picture that pops up if you Google
Oh,
his
you
name.
already know, man.
Yep.
Right, exactly. So like there's prejudice right there, but the point being like we don't know like the evidence that on which this assessment was based on. We don't know how that assessment was made. We don't know like the conversations that were taking place, and all of that is just sort of assumed and is also now the reason for getting the cameras kicked out.
Mhm.
And so there's been, you know, not only with the body language and the lip reading that had sort of been said to like, oh, he's saying like, you know, Erica Kirk. Yeah, you know, he was talking about
Sucks.
Erica Kirk, and yeah, or like I didn't know that he had a wife or something like that,
Yeah,
and smirking, and so therefore it was, you know, blah blah blah, and then you have TPUSA sort of running with that, and Jack Posobiec, and
Oh yes,
blah blah blah, and then Candace goes off and says,
big old
"Oh
mouths.
no." Candace is saying like, oh, she has a source who knows exactly what Tyler was saying in the courtroom, and what he was saying was like, there's a fender bender on the way to the courtroom, and it's like, what is happening? Like,
Right.
what are these sources? Right? What like what? Anyway, so
Yeah.
just,
It's
just
bit
a thought.
much, and you know, I would be totally fine with them. You know, with none of that. We don't really need any of that. Whether it's actually doing any harm or prejudice in either direction, I'm fine without all that. We don't need all that. I don't think that's really helping. So,
Yeah.
especially when it comes down to, oh, is he saying he's guilty or is he talking about a wreck at the intersection? You know.
Yeah.
And I'll say this too. My opinion, especially in a very conservative state, as I understand Utah to be, again, going back to the original statements by the president, the governor, the attorney general, like there's a good argument, I would say, that he might not be able to get a fair trial in Utah.
Oh, I know.
And
I mean,
that's kind of
how
what
do you get a fair trial? I mean, it's like it's one thing if somebody from UVU or I mean even one of the prosecutors, if one of them comes out and says something a little, you know, prejudiced, but when the president of the United States, I mean, you're talking about the biggest voice platform, you know what I mean?
Yeah.
Like everybody hears when he speaks. So,
Yeah.
I mean, I don't know what you're doing. What would they do in that situation, Greg?
I
I
mean,
get it.
you know, it's a state case, so it's not like you can just transfer it to a whole other state. I mean, obviously within Utah, they would have the opportunity to like switch venues around potentially, but really because it's a state case, I mean, you're stuck in the state.
But I mean, if it was an issue with the president, I mean, it's not a matter of the state, like the whole
Yeah,
United
well-
States, the whole world heard it. So,
Well, yeah, no, I'm saying just as far as like this proceeding is obviously
Right.
brought by the state, so it's
Yeah.
gonna have to be litigated in Utah. But you know, with that being said, you're right. I agree. It might not be, at least in any conservative state, you know,
Right.
able to get a fair trial per se. But you know, it's just like I said, it's unique. I don't think we've ever had the president of the United States come out like within a day or two of an incident and be like, "Oh yeah, this is death penalty. You know, this person's guilty." You know, and so yeah, it'll be interesting.
but
to
one
see
thing
how
that
it
makes
goes.
me feel a little better about it, I get what you're saying with, you know, it being Trump and the conservative states and all that. But at the end of the day, I would say, yes, there's a lot on either side, but at least the ones I follow, the majority of the people
Yeah.
that are going hard against the Fed slop narrative are, you know, somewhat conservatives, you know, slash Trump supporters in some form or fashion or
Yeah.
at some point, you know what I mean? It's not like most of the people that are going against the narrative are all lefties, you know, so.
So I would imagine that voir dire, you know, when they question jurors, that might take a week in this case.
Yeah.
You know,
Yeah.
and rightfully so. But I think it's going to be a pretty lengthy process. As it
I mean, who
should
cares
be.
if it takes a month, honestly, if you can get a good jury.
If that's what it's required to protect his rights, then they need to have all the time they need.
Yeah, absolutely.
So one of the things, there's a couple things, and you know, one of the charges I think is, well, Well, one of the reasons it's a death penalty, I think, is because he sort of he stalked Charlie, and sort of killed him for his political beliefs, which I believe has one of the reasons why it becomes a death penalty case, as well as
talking about Iran war. I'm just kidding.
as well as hiding the clothes, which is why they needed to be hidden, as well as the gun, as well as taking the shot in front of a child. And so all of those, I think, are reasons for it becoming a death penalty case. But one of the questions I had was, Kash Patel was sort of saying, like, I don't know if he's officially closed the investigation, but he said something to the effect of, like, we're letting Utah kind of take it. But I guess my question is, if it's sort of a political assassination, are there federal charges here that Kash and the FBI, I guess, could bring?
I think they could have
later?
taken it.
Oh, without question. And just on this simple basis alone is that
I'm surprised they didn't.
if I understand Cash's position, the FBI's position is that this was
Political.
a big deal. Like, there were multiple people in multiple states involved online or part of Tyler's group. Like, if the feds wanted to claim jurisdiction over this, there's multiple. I mean, I'm sure there's probably some federal laws that were involved, but also too diversity, right? With a bunch of potential suspects, defendants in multiple states. So yeah, I mean, they could have concocted, not that they would have to manufacture it, but like they could have put together.
They had
an
plenty of
argument for
grounds to
federal
do it if
jurisdiction.
they'd have wanted to, right? I mean,
Gotcha. So does
yeah,
that
I mean,
mean-
because the definition of terrorism is, harming someone for political ends. Obviously there's more to it than that, but I mean, I think that they could have if they'd have wanted to.
Oh, I mean, maybe a RICO charge. I mean, there's a lot of different, very wide-reaching federal laws.
But that would assume that there's a conspiracy and he's not a lone gunman.
Yeah,
And I think
exactly.
that
That's
is-
what I was
that
saying
is-
earlier.
They don't like
so-
that.
Yeah, well, Kash was basically, and this is the sort of issue that I think so many people were having. Kash was basically insinuating that the investigation was still open, that they were looking into these different groups, like Armed Queers SLC, like John Brown, like all of these leftist groups, right? And this kind of allowed people to kind of do the same type of speculation as people were doing with Tyler Robinson's body language or whatever, in order to like make these sort of weak links to these other things, including 764, including like Venezuela, including like Iran, right? In which case, like, oh, here's Iran linked to this assassination, and now we're in a war with Iran. So I just, that was kind of interesting to me, just sort of how it was framed in a way that allowed certain conspiracy theories, but not enough to like actually bring them in a way that would get this out of Utah. Right, because talking about LDS, and I'd be curious of Greg's thoughts on any conflicts of interest if the judge, the prosecution, the maybe the
Was
defense,
LDS.
all of these people, all the media, like the local media, right?
I never thought of that.
So it's there's that. The other thing that I also wanted to bring up was these California lawyers did a really thorough job explaining about the issues with regards to the shackles and being videoed in shackles. And it was an issue that was getting litigated in California. And the problem was that California was potentially set to make a ruling that would affect potentially the entire United States. But the but the case in question in which that could have happened basically ended before that could get ruled on. And so here now, and so you move from a liberal state now to a conservative state, which is doing the exact same kind of, trying to make the same arguments and still sort of making precedent, I guess, for the entire country, but now with a conservative judge potentially. And so, whereas a liberal might side more on the side of the rights of the individual, conservative court might rule, more in terms of the security of the state. And so we potentially are litigating whether or not everybody across the United States can be put in shackles before any evidence or even hearsay has been provided that can potentially bias the jury or the court in order to have a higher rate of conviction, which could potentially violate the rights. And so that's kind of one of the other issues I'm sort of like, and why I wonder, what's going to happen on this.
Well, so that's a very good question. So, as far as precedent, a California case would definitely be applicable only in California, Utah case only in Utah. Now, if it goes up on appeal for federal constitutional rights, obviously that's when this case could potentially have precedent-setting capabilities across the whole country. But I'm just surprised that they haven't really firmly addressed this already. But I guess it's one of those things that not every case has this level of media coverage and scrutiny. So now we're just looking at it under a microscope, this one issue about the shackles. But no, I agree. I mean, in my opinion, absent some very compelling reason, like this offender is violent, maybe they made statements that they're going to act a fool in court, something like that. I think all defendants, especially when they're with their lawyers at the counsel table, should be able to present themselves in normal clothes without shackles, just without, obviously if there's, again, some reason why not, I think it should just be the rule that when you're at court with your attorneys at the table, you should not have to wear shackles.
Yeah. There are some people that are violent and that definitely
would be a danger
to But wasn't there that alleged Trump would-be assassin who failed, who tried to kill himself with a pen or something? And so this was part of the suicide claim that was unclear how that claim came to be or how it was assessed or whatever. And I think that may be how they produced the need to put him in shackles in the first place, for which all of this other stuff was then used to kind of litigate that part, I guess.
Let me say this. As far as, again, my personal experience in county jail was in Texas, is that you don't have to do much of all to get in that turtle suit. As a matter of fact, I was attacked in jail one time, and because I was successful in, defending myself, they put me in a turtle suit in isolation cell. And so, I just say that to say is, I'm very curious as to who made that decision, why they made that decision. Because it just seems real convenient that right when all the preliminary arraignment and all that was going down, they have our boy sitting there in the turtle suit, and it just looks terrible. You know what I mean? You look at someone in that and you say, oh, well, they're suicidal, they're violent, they're crazy. So I would really be anxious. Well, I'd be curious to see how that was done. Yeah.
Yep.
Yeah. And this is another issue with regard, because I think the defense was basically saying that, the Washington County is really only a witness and doesn't have standing. And there was this question of when the handoff of Tyler happened, along with any of the information, from one county to the other county, and so therein lies another, reason for some of this discrepancies, whether it's the timeline, whether it's the question of when the guy was Mirandized, all that stuff. So
Lord knows they've got their share of discrepancies.
Yeah, there's a lot of them, and so it just raises the question, like, and again, we'll put our tinfoil hats on a little bit, but it just seems like a lot of this is just congealing together very conveniently against Tyler Robinson, and God bless. Particularly Barron, Candace, these other people who are doing hardcore investigations, like, God bless them for that, because otherwise we might not have had any idea about these discrepancies. And so I'm glad we do, obviously.
Yeah, for sure.
Yeah.
I don't know. Hopefully somebody doesn't screw it all up for everybody. But I believe the judge knows, and I believe everybody at this point, everybody who is anybody, knows that if the media gets locked out, that we're going to have a problem.
Well, the media is already getting locked out, I think, and therein lies the problem. But the way that I see the judge happening is he's sort of being promoted as this very fair, very reasonable, very kind, very balanced person. The defense is saying we don't want anything to be seen. The prosecution's like, oh, we don't care. Media doesn't even really care if they get to see anything. But what that allows for is the judge to sort of come in a balanced way and only, disallow certain key pieces of evidence from the scene that would be prejudicial. And so the effect of that is, like, the public gets to see all of this prejudicial stuff, like all of these videos of some person you can't identify or this or that. But when it comes to, like, the absolute, like, things that would potentially put this away, those are kind of only shown behind closed doors. And so we sort of have to take for granted that the defense is doing its job, that
doing their job
do happen, that the prosecution or the Fed are not fabricating these, or manufacturing these exhibits here. So it requires believing the people involved here.
Yeah.
And
I feel like evidence-wise and exhibit-wise, we should see all that. I mean, once the trial starts and they're showing exhibits, I mean, yes, I understand some evidence is going to be, some evidence is going to be, what's the word I'm looking for? I mean,
Prejudicial.
Prejudicial, Lord. But at the end of the day, some of the evidence is going to be exactly the opposite.
Exculpatory.
Exactly. It's going to be exculpatory, and you're going to, as long as you see that and along with, examination, cross-examination, and all the back and forth where everything's scrutinized, I mean, at the end of the day, hopefully the public would come to the same conclusion that the jury comes to.
So if I understand this correctly, what Echo was saying is that basically they're going to take the May pretrial date that they had set, and they're going to do, and this is just my understanding, basically, so a motion in limine is a pretrial evidentiary motion where before trial you take it all in front of judge, rules, we'll admit this, not admit that. So it seems like they're doing that also in front of the preliminary hearing. And so that way judge will be able to sort all that out. And then when we get to the preliminary hearing, only evidence that I would assume he's reasonably confident that would be admissible is all we'll get to see, because just based upon what I've seen from the media and the prosecution here, I would be willing to bet that there's probably some pretty prejudicial hearsay items of evidence in the record that I'm sure they would probably want to try to admit. So it doesn't ruffle my feathers that they're doing this, before the preliminary hearing, but most definitely a trial, once we get there, then it all just needs to come
and
out.
that's a good point right there. Nosy said, the media should not be in the courtroom until the jury is. And that I can kind of understand. You know, like I said, you know, maybe even for the preliminary stuff, it wouldn't hurt my feelings if the cameras weren't in there then. But like I said, once that jury comes in, that's when I really want the cameras to be there.
Yeah.
To the point, Greg, I think what I heard was that May 19th is going to be, I don't think it's going to be an evidentiary hearing. I think it's going to just be arguments that will be made. And then based on those arguments, because the evidentiary hearing is prejudicial, at least the defense is saying, they're arguing in the May 19th why it should be closed, I think.
Okay, so the hearing itself, not just certain items of evidence.
Yeah,
Okay.
and then later on, based on how the judge rules, then they can sort of go, I guess, one by one on the particular exhibits.
Yeah.
What was I going to say? Last thing on that. Oh, and then the defense just like filed a motion saying we want the state to ignore its own constitution because what the Utah Constitution allows is for hearsay to move past the probable cause, and so that would be all of this, prejudicial stuff that would prejudice the jury.
Yeah, and one thing I'll tell y'all too, I was talking about the motion in limine, which is like the pretrial evidentiary hearing. Please realize that, like, even if judge rules in that hearing on that motion that, hey, this item of evidence is going to be inadmissible, the party still has to offer it at trial in order for them to establish a record where they could appeal. So it's like, let's just say that the May hearing was going to be something like that. Even if judge ruled some of that stuff inadmissible when we go to the preliminary hearing, technically they would still have to try to offer it. So in that way, we would still get some type of sense of what that evidence is. So, but that makes sense with your point, Echo, that they're just going to do a hearing about whether the media is going to be allowed in the hearing, point blank,
So that kind of got figured out today, as did the continuance. And then the 19th, I think, is going to be about whether or not the preliminary trial or preliminary hearing should be closed.
Mm-hmm.
And then they filed a motion requesting that between that time and the preliminary, they should go through each of these different exhibits to sort of determine if they're hearsay prejudicial, which would not be admissible for the actual trial. And then they added all of the different exhibits.
Speaking of which, do we want to go through some of that?
Yeah, that's fine.
You want to finish the video and we'll see kind of anything else that...
Yeah, we'll see if there's anything else there. Let's see. We'll pop it back up here real quick. And here we go. Let's see what else Judge has got to say here.
If the parties will be prepared to address the motions that are outstanding. Turning to the defense.
Your Honor, I believe, are you talking about the ones that have been fully briefed at this point?
That's correct, or anticipated to be fully briefed before that week begins.
Yes, Your Honor, we can be prepared to do that.
All right, and to be clear, do you want to put on the record the motions that you wish to address at that hearing, just so all parties are on notice and we know how we're proceeding?
Give me just a minute, Your Honor, and I'll pull them up. I know one of them is the motion for the order to show cause and compel discovery. I know that one is pending right now. Just 1 minute, let me pull them up.
Kathy, while you're doing that, Your Honor, I show 3 outstanding motions. The one is the motion for an order to show cause and contempt. That is fully briefed. I believe that's ready to be argued. Actually, I think that's a notice to submit without argument. Is how it's been submitted. The second,
Somebody's got their God bless
Yeah,
him
more
little
shut that
ankle
dog
biter in
up,
the
man.
background.
second is motion to close the preliminary hearing and seal exhibits. That was filed May 1st. We intend to use the full 2 weeks to respond. If the defense intends to reply, the reply will be, I believe, the 21st, which will be the day before the current preliminary hearing dates end. So I don't know if they intend to waive that reply time and argue at that time or not. And the final one is the recent motion the defense filed to find the use of hearsay at the preliminary hearing unconstitutional. We intend to use the full 2 weeks to respond to that. It also hasn't been served on the Attorney General's office, so that one will not be ready by the time of our preliminary hearing dates. We're gonna have to find another date for that.
And that, I think, was
We've
specifically.
also objected to the motion to close.
I think that one was specifically claiming that the Utah Constitution was unconstitutional because it violated the federal rights of the defendant with this preliminary, this reliable hearsay, which basically includes Fed reports, testimonies that are verbatim transcribed, and other things like that.
Yeah, and
The still exhibits because it's.
Oops, sorry, I didn't mean to unpause it.
Yeah, I was just real quick. Because basically what the state was trying to do is come into the preliminary hearing just providing these summary reports to the defense.
No
without
underlying
having,
stuff.
any capability of like getting a counter narrative from their expert and
Right.
stuff.
And so
I
can't
think that
even-
violates his rights.
Yeah, can't cross examine. So Lance Twiggs, for instance, is one of the not a witness, but the I guess verbatim transcription of Lance's comments
Mhm.
will be entered, but the defense can't cross-examine
Right.
And
as
That's
well
not
as and can't cross-examine the agents who put together the report.
yeah. And
I
that
think that stuff should be kicked out. I think that shit should just go. Like if
Right.
you want to use his testimony, put his ass in the seat.
Well, and that's the thing. Like, it's not admissible. If I understand it correctly, it's not admissible for a trial,
Right.
but it is admissible for the probable cause hearing, which is
Yeah, see, I just
significantly lower threshold. Which is why they're saying this is unconstitutional. Which I gotta say, I kind of agree, and I would be very concerned if I lived in Utah and this was
Yeah, let me say this about the text message. This is my theory. I mean, I really think that the state's case is highly contingent upon those text messages being admitted and entered, and the only way that that's going to be able to happen is with Lance Twiggs getting up there and what we call authenticating them and saying on the stand, yes, I received these messages from Tyler's number. And I just have suspicion about those text messages. I do.
too. Yep.
Well, because if you look at the charging document, they first of all they came to sort of look at the Discord pictures, and then in the probable cause affidavit, it just switched. It doesn't even. It just mentions. It just goes on to talk about messages, and so everybody was sort of thinking, "Oh, it's the Discord messages still." But then in the criminal information document that came out like 5 days later, it showed that it was text messages, except what they did was the agents or the sheriffs or whoever was checking this were just taking pictures of the text messages on Lance's phone, and so there's no like metadata, there's no electronic,
right.
there's no electronic extraction,
Yeah.
and the way that they are linking it is because the contact name says Tyler with a happy face, and so therefore those text messages must be Tyler.
No.
Yeah, so that's and just think about that, y'all. In the digital age, and it doesn't take an expert in evidence in the law to understand that, having the metadata, especially if those messages are going to be challenged, why would an investigator just take a screenshot, man?
God.
They have the experts, I think, probably working for the state that they could have just sent the phone to download and get all that. So again, just a lot of irregular stuff here.
Right. And the answer to that question would be specifically so they don't have that metadata.
Exactly.
Well,
Exactly.
And
I mean, that's the only conclusion I can come to.
Yeah.
Right?
I mean, really?
And not only with that, right, but with regards to this this so-called handwritten note, which I think
the burnt
is
one.
Yeah, the
yeah
burnt one.
is lit on fire, right? So you can't see that.
I
And
wonder
so,
if the picture actually has it on fire.
Hey, let
Well,
me ask
yeah,
y'all
right.
this. Let me ask you this. Was it
But
Lance
just
that burned it?
so it's unclear.
I think
right?
it's
But-
assumed.
but
Because
we're gonna
that's
have this,
obstruction
like-
of justice, like tampering with
Right,
everything.
so that's a thing, right? And and so the argument that you could infer is like, oh, Lance destroyed that note, and then because he had destroyed that note, the FBI came in and through what Cash called aggressive interrogation techniques or whatever, which could compromise the witness in the first place. Somehow they were able to reconstruct this note.
This
And if
burnt
you
note.
look at this burnt note, right? This destroyed
Wow.
note that they reconstructed. And so the way they reconstructed it, and if you look, I think this is in the warrant or something, that was not in the docket, but was from the sheriff's office. Basically, it's just Lance telling the person like what that includes, right?
Yeah.
So like, oh, okay, so Lance is reconstructing this from memory during the course of this aggressive posturing that is potentially telling this person without a lawyer present, if I understand correctly, that and he's just remembering this like 5-line like thing,
And this
like
is-
he's memorized this entire thing, right?
This
Like,
is coming
so-
from the kid that's got all the all the paper up everywhere with all the crazy scribbles and
Right,
symbols.
exactly,
and-
right?
Yeah.
Yeah, and I should say that's Turkey Tom, right? So
Yeah, Turkey Tom.
Is that a
Turkey
Fed
Fed Tom,
plant
no.
itself? But I think
Yep, yep, yep.
also in that warrant it says that Lance took a picture of that handwritten note, potentially before he lit it on fire, right?
Yeah.
So again, there's no handwriting analysis,
Nope.
right?
Nope.
There's only the word of this alleged like person with their own diagnoses.
I mean,
right?
they could analyze the shape, and they could analyze the shapes and everything.
Yeah,
but with
no.
handwriting analysis, there's pressure. They check like how much pressure was put on the the pen and all that.
Right,
on
but
the
you
paper.
can't do that now
Right.
that it's lit on fire. But you also have this. So you have this burned like charred thing that you probably can't see anything from. You also have this like picture of that note before it happened, and then you also have this like recorded testimony of this person who is unable to be cross-examined, and it's only going to be kind of shared, but it also might be shared because it would be prejudicial, in a way that nobody can see it, right? So like that's the level of probable cause. And if you're like skeptical of the police, and you're like, it seems like you might have kind of planted that shit there,
Right. Yeah.
It's
I mean, look,
but apparently that's all you need to sort of move on to the next phase.
and they're
at
going to
least to move on.
take his recollection, to reconstruct this thing, and they're taking it from a guy that can't even successfully completely burn a piece of paper.
I just, man, I'm telling y'all, I think that the majority of their case is really hinging on the stuff from Lance Twiggs, and there's no telling how they got him all twisted up in the interrogation. But I guarantee you what they did was get him all twisted in some way, and kind of maybe how they got Tyler. Maybe he was looking at something on the internet or something like that. But either way, I think they got Lance in there and basically told him how this is about to go.
I mean,
Either that or he was way read in from the get-go. Because like I said, I have a strong feeling that there's at least a very good chance that all of the Discord stuff was Lance.
yeah,
Allegedly,
and, well, Yeah, or this entire thing is an op,
Yeah.
and they're all just like playing their role, so that the cumulative effect of all of this is something we haven't seen yet.
The question
But
just is how much of this was laid out? Like how much of it is an op of opportunity and how much of it was actually scripted from the beginning, Obviously
exactly.
it's an op and obviously it was planned, but I'm sure they've had to adjust along the
Yeah,
way.
and what is the op in particular? Right? And what is the specific conspiracy that is being alleged here, and what, if any, is the proof for it? I did want this. There was one thing I wanted to remember, and ran out of my mind. So yeah,
Yeah, it happens. So yeah, I think that's just silly. And to me, again, this is why I said that it wouldn't hurt my feelings if the cameras weren't in the courtroom for the preliminary, stuff. And as long as they have them, as long as they've got them in there when the jury's in there, because again, stuff like what we're discussing right now is going to prejudice Tyler for sure. But at the end of the day, if it ends up not being admissible, and they can't really assess this stuff, and there's no real argument or nothing against it, then again, like I said, it's prejudicing him for no reason, I guess, to the public. So I mean, I understand that part. But once everything has been, once everything's been hammered out, and like I said, the jury comes in there, that's for sure. That's when the cameras need to be there.
yeah.
Yeah, with these text messages, I was just saying to Katism, like I really do think if Tyler's attorneys, and again, this is just based upon what I understand, like no metadata, stuff like that. I mean, if they really properly present and argue it, I think there's a good chance to get that stuff thrown out. And if that gets thrown out, considering the bullet report, all that stuff, it's not looking too good for the state.
But you know what? Even though, and here's the thing, like, it shouldn't look that good it doesn't look that good for the state. And yet, like, if the defense is like, in on it to whatever degree they are, they've been losing every motion, right? Just about, except for, ones that allow them, a sort of semblance of neutrality, but, or at least the optics of it. But if they're, there to lose, then what you can have is a case that should have been won that ends up being lost. You can, you've got the narrative, you've got the media sort of creating a narrative that sort of justifies why they lost it, despite this bad thing. And then you have and then potentially you also have the pressure of the jury that is potentially highly biased, as well as the judge, who are like, there's only one suspect in this case and we're going to let this person go. Like, I wonder if they just sort of convict him, despite the weak case that they have, and the effect of that long term as well. So
I'll say this, and this has just been my experience. Especially in federal court, and now that we've seen the E-Team files and all this, I think people are now understanding that. And this is all Operation Mockingbird, right? Like the CIA.
Oh yeah.
People think that the federal government, that their investigators are super incredible, that the U.S. attorney would never get up there and lie to a jury. And
God.
I think people need to start reassessing that at the state and federal level. But to Echo's point, I could see a jury in Utah, the proper jury. I mean, not saying it would be a proper jury, but if the state was able to assemble a proper enough jury, they very well might be able to get him convicted despite the lack of any kind of like solid evidence.
I think if the defense is able to get a decent jury, you know what I mean? Like, I think if they're able to actually find an objective jury, I just think there's too many holes, too many questions, too many,
And to the point that Echo was made about the potentially that like this thing is connected all the way around, defense attorneys and all that, there's been a few things that really piqued me to that. One of them, and I did a video series on this, is the selection of attorneys, how that happened, right?
Yep.
There were qualified attorneys who
And
were
why didn't he
really-
get his initial
yeah,
choice,
who
his initial
really
pick?
wanted to take the case, but the guy who's consulting the county on picking attorneys for this case said that he didn't pick them because they wanted it too much. And then with Catherine Nestor, even though she had that Curry Richens trial going on, they still picked her anyway. So that was one thing.
And she said in open court, "Look, I've had all this going on. I haven't had time to concentrate on this case." Like that that makes the defendant feel real good.
Yeah, and number two was the January 9th motion, making the potentially, or what I do believe, exculpatory evidence in a private motion. Like that just doesn't add up to me, especially with the media climate as it was, everyone beating up on him. I just can't imagine why they would have done that. One thing I will say is that I think that these death penalty attorneys, which I do think his attorneys are qualified, but let's be realistic.
Oh, they're definitely decorated attorneys. I mean,
I'd be willing to bet most death penalty cases, there's probably not a huge fight about guilt or innocence. I mean, not saying that they don't.
It's just a matter of getting the Senate, keeping them off death row, and getting Yes, for the most part, it's not about getting them off.
And that's another thing too, is that they announced death penalty like even before they found Tyler Robbins. It just really, really quick. And so I take it even a step further back and say, was that a move to be able to put the decision on who the lawyer is squarely within the circle, and then all the chain reaction from there? So again, I've been kind of assessing it, Echo, from every position, and I haven't ruled out that it's all the way around in on the op.
To that point, I think one of the claims that has been floating around is that I think it's Michael Burt or one of the lawyers on the defense is actually connected through family and marriage to I think it's Farnsworth, in TPUSA, right? So like talk about an op there, and then also the whole thing with and maybe you have some thoughts on this too, Greg. The whole thing with the Harpole lawsuit against Candace now, that law firm is also related to
Daily Wire, his
Daily
sister.
Wire, to Ben Shapiro, right?
Yep,
and then the attorney general or something. I forget who it was.
The attorney general.
So there's that.
No, not the attorney general. I'm sorry. The what is she? She's over the civil rights division at the DOJ. Harmeet Dillon.
Yeah, thank you. Yeah. So there's that. There's also the fact that like only 33% of people in the county where this is taking place like even want the death penalty. I think. As well as the fact that like it is.
It's an interesting number, by the way.
Right. And I might, to be clear, I might have thrown that out, but I do think that's what it was. But so there's a very it's definitely not a majority who even wants the death penalty, especially when there's so much kind of questions here. But along with that, and the fact that it's sort of costing millions of dollars, and death penalties like going to be even more expensive than life in prison. But there's also now the fact that like if you look at who's the witnesses who are being called and what the exhibits are, and the sort of motion that is saying like, oh well, we may not go forward with the DNA because of these questions. There, if they don't have the DNA reports, and I think there's a few of them, if the parents aren't on this witness list, and neither is the grandpa, there's no way, and the things are inconclusive. There's no way, except for these text messages that people are saying like, oh, they're modified, they're AI. There's no metadata, there's no electronic extraction. That's the only thing that can tie Tyler to this gun And we haven't even seen the gun, and neither has the defense hasn't even seen the gun. Right? It's still in Quantico, but they've got pictures apparently. So anyway, point is, it's seems to be getting worse and worse. But also the threshold is so low, the bar is so low that that they're going to go through, past the probable cause, at which point, Tyler can potentially take a plea, and there's enough narrative structure there to justify it on the basis that maybe on the one hand he didn't want his parents to have to testify, he didn't want his lover roommate to testify, and therefore he takes the plea. We don't see any of the evidence.
That's what I'm afraid of.
Goes to jail and sort of gets executed, but also maybe
Epstein's
they
himself.
just sort of or transfer him and sort of give him a new name and set him up on a Israeli kibbutz next to whoever, right?
He'd be hanging out in Tel Aviv.
So, Echo, you brought up a good point. Another thing that I'd forgotten that kind of put me on to a potential widespread op was the death penalty. So I don't know if you know this, is that the Republicans in Utah just a year or two earlier were gathering gathering a majority to get rid of the death penalty in Utah, right? So that didn't really go through at the time. But then after Tyler Robinson's case comes up, now
Well, we need it
sudden,
now.
Yeah, the Republicans in Utah in the state legislature now want to make the death penalty even more strict and more favorable for the state. And so my thought was the only reason they're doing that is so Tyler Robinson in his jail cell can read that and say, oh, well, I might not have any fighting chance in hell to win this case or win on appeal. So that was another thing. I'm glad you brought that up because that was another thing that I looked at and I'm like, this is weird.
So
one other thing, and just on that point of if you look at what the different death penalty, what turns us into a death penalty, it is like hiding the evidence, stalking somebody for their political beliefs, not only hiding the evidence by hiding the gun, but also hiding their clothes, and then the taking the shot in front of
the kids
child.
the child.
And so if you take those things and sort of backwards design the narrative that you need, you can now understand why he's doing stupid things like hiding his gun when he could have just walked out, right?
Yeah.
Shooting in a public place when, didn't need to necessarily do that. The whole issue with the changing of the clothes, et cetera, which then...
and not only did he do that, he did it like 6 times.
It's unclear, right? There are these gaps, and we're sort of being told this narrative, and we're like supposed to make these leaps in judgment or these logical leaps in to conclusion, and it's all based on this sort of projection that is confirmation bias based on this sort of anchoring pieces that the feds showed us, and they literally said, like, we showed this to you so that we could anchor the public's understanding that there was somebody on the roof, and now we don't have to investigate anything else, and we can just kind of limit it here.
And let's not forget about paving over the crime scene.
Oh God, for sure. I mean, yes. So let's think about this. Like, obviously, we don't know every single thing that they do have, but what and how could they tie him to this enough to convince an objective jury that he did this? We already know. You've got don't you have you've got the Lord have mercy.
Exhibits?
Yes, you've got the list of exhibits, don't you? So we know for a fact that, it appears that there is going to be no testimony from the dad or from the granddad or from Lance.
No grandpappy.
Now,
there's going to be
what has Gary been saying? What has Gary Melton been screaming for? You're going to see he is testifying for the state. You're going to see him get on that stand and tell the world that, that his son confessed to him that he did this. You wait. I mean, like, it is constant.
Yeah.
And,
Well, and
obviously that's not going to happen.
No, I mean,
Well,
because if we look at the charging document, the way that they present this confession is anything but a confession.
Yes. I mean,
The
all that was
inferences you
said
could
was
draw
that he,
from it, but it's not a confession.
it was, right. It was an inference. I mean, all that was said was that his parents said that he indicated to them that he had done it. Indicated could mean anything.
Insinuated, yeah.
Like I said, all he had to do was like put his hands in his pocket, not say anything, stare at the ground, kick a rock. I mean, oh, well, he must have done it.
Right.
I mean, like
Yeah.
indicated could mean all kinds of things.
Yeah,
That's far from a confession.
yeah.
And
Yeah,
they say we got
and
4 confessions, and that's
right. And 2 of them are, discords that aren't actually linked to his actual name.
one of them's a burn ass note that was
That's a burned ass note.
a picture,
And,
a picture of a picture.
another one's a text that, it's unclear what the, if they're faked or what.
Right.
But the goal, I think, for people like Gary and the sort of Fed slop, that is, again, just trying to posture and trying to sort of pretend they can predict in order to create and establish that narrative that, doesn't need to come true, but it's just to sort of stall while presuming that they have all of these things, because, why wouldn't they? But then when it comes to that time, you see, we don't have certain people that we said we had, but that doesn't matter because they'll do it at trial, right? But then we roll around a couple, it may be the case that we don't see those people because he takes a plea deal, right? And so what we then have is contingent of Fed sloppers who are repeating the narrative that has been handed to them uncritically, just like the media. And that sort of gives them cover. So when this completely falls apart, and it basically already has, but for the Utah Constitution that allows a fallen apart case to proceed, we get to the point where it may, none of this evidence may even be seen because of the tricks that are.
Yeah, that's going to make me. That's going to really make me upset.
I think you hit the nail on the head, Echo. I think that this was all intended to put so much pressure on him that they might not have. I mean, I think the original plan might not have even been getting to the preliminary hearing.
Yeah, I don't think he was supposed to make it to the jailhouse.
Yeah, they're falling short. I mean, look, as an attorney in a death penalty case, if I was the prosecutor, I never would be a prosecutor, but let's just say hypothetically, I'm always going to try to bring the best evidence I have. So if I have expert reports, I want the experts to show up and testify, right? And so seeing them falling so short, even at the preliminary hearing, even though I do understand the standard's low, they don't have to introduce that. I think it's just kind of weird and irregular for me, like as a lawyer, to not desire to want to bring, and there's actually a rule. So at trial, it's called the best evidence rule, meaning that if there's a certain type of evidence, you need to bring the best form you have, the most admissible, reliable, solid form. Obviously, that doesn't apply necessarily at the preliminary hearing, but I just find it, for me as a lawyer in practice, to always try to show up
instead of a report that says they found DNA consistent with Tyler Robinson's,
and 5 other people.
And 5 other people. Let's see how the DNA was collected and exactly what tests you used to, I mean, it's like I've said, I know I sound like a broken record, but consistent with could mean anything. I mean, I got 4 kids, and I can guarantee you all 4 of them have DNA consistent with mine.
Right.
Yeah. I think that's a pretty reliable.
I mean, some of that DNA is an exact copy. It goes from parents to kids. I forget what that's called off the top of my head. Now, obviously, they do have their own, unique also part of that. But regardless, I mean, like, consistent with does not mean this test was conclusive that it was Tyler Robinson's.
Well,
Right.
yeah, and well, and also too, it's like, okay, well, if it's consistent with, I mean, I think they found 5 different DNA profiles or
Yep.
something. Like
And I'm
on the
pretty sure I can tell you
Well,
3
all
of
those
them.
People need to be looked at. You know, what I mean?
Tyler,
Like,
his daddy, and his granddaddy. So who's the other 2? Lance
I
is
don't know.
probably
That's
number
good
4.
And,
And then-
I think there might have been another roommate in that house that left, but I could
Well,
be
number
wrong.
5 could be Mr. Patel. You never know. Allegedly.
Yeah, right. And I mean, and I think if I remember correctly, the they put somebody new in the Utah.
Yep. That field
public-
office.
Well, the
the whole
okay.
definitely the FBI field office. Yeah, there's a new one, and he came from the Washington
Yeah.
D.C.
The swamp.
office, and also I think he specifically had expertise in cyber security or their cyber kind of command or whatever,
Mhm.
as well as in the sort of evidence kind of, I forget what that is called. So he would be the person who would kind of know the process on the one hand, but also I think the Utah Public Safety sort of bureau,
Yes.
which within that is the Utah State Bureau of Investigation. So the head of that whole kind of thing is new. The judge is new. The UVU police, I think the chief is relatively new.
yeah,
And
he let
so-
Farnsworth right in front of him just tamper with that.
I was going to say everything was new. It was the
hope he
first
knew.
time Charlie was raised up. It was the first time Farnsworth was there doing what he was doing. It was, I mean, a lot of firsts. Hey,
Yeah.
while before we end up running out of time, which I mean, I'm not saying I've got time, but just so we don't forget it or run out of time on it. Brett was asking about that. So his parents are not on the on that exhibit list,
Well,
but he's
that-
asking about
Yeah.
the witness list, like because
Usually
they're not
there'll
on there.
be-
What does that mean?
Yeah, usually there will be a scheduling order for that stuff. So, like normally, or at least in federal court, judge would issue an order at like the beginning of the case and say, okay, well, 14 days before the preliminary hearing, we need to have your witness list or exchange witness list, and then 14 days or 21 days before trial, you'll exchange a witness list. So it's usually set by court order, the timing of that, but in Utah, they might have a specific rule. I don't know for sure. I can definitely go look, Brett, but normally that timing is set by a pretrial order.
But them not being on the exhibit list means that they will not be at all in this preliminary hearing. Doesn't necessarily mean they won't be on the stand come trial.
Well, yeah. So are you telling me that his parents aren't going to be there to testify?
No,
for the
we
state
haven't
preliminary?
we haven't got to
the-
that yet. But
the claim I think that the prosecution had made, well, let me rephrase, in the charging
Gary
document-
made it anyway.
Yeah, right. In the affidavit, yeah, exactly. So in the affidavit and in the criminal information document, it is alleged that the parents had a conversation with their son in which he insinuated that
Yeah,
He had
indicated. Yep.
Charlie Kirk, or it was insinuated being the key word. The inference that was made was, oh, well, then therefore they will have the parents, testify on the stand against their child. But
Because they talked about how in Utah there is no law. You still cannot be compelled to testify against a spouse, but in Utah you can be compelled to testify against.
right, but that's the prosecution's witness list.
Yes.
The question I would have for Greg is when it comes to a probable cause hearing, the defense has indicated that they have a couple of expert witnesses, and they have added those people in, but they, I believe, were supposed to be testifying about the DNA, but the the prosecution had not even given
Yeah.
the results
The
to
underlying stuff.
Yeah,
right,
the
to
underlying
the defense.
data.
In which
Yeah.
case, the defense's witness would not have enough time to, on the one hand, even process it and see it by the time the probable cause hearing would happen. So my question to Greg is:
Mhm.
Is the probable cause hearing? Does the defense bring witnesses beyond experts? Like, could they bring, say, another roommate,
Fact witness, like a
yeah, or is that saved more for the actual trial, and the probable cause is just really about what is in the affidavit, in the probable cause affidavit, rather than and all the information there, as opposed to having the defense provide character witnesses or fact witnesses or stuff like that.
Without knowing the specific rule in Utah, I would say this: that yeah, they absolutely can bring, obviously experts in order to challenge. But I would say this: it's probably going to be limited to challenging whatever the state brings. So if the state brings a witness,
Right.
to prove the
Yeah.
probable cause, if you have a contrary eyewitness or an expert witness, then I absolutely think that that's fair game. Now, trying to
Okay.
present alternate theory witnesses, stuff like that, might be out of the realm for that, but definitely directly challenging whatever the state brings. Absolutely, they have the right to do that.
Gotcha.
So at the end of the day, I
and-
just want to make sure I understand. I mean, I think I do, but basically this hearing that's coming up is not really, it's really not for the defense. This hearing is for the prosecution
Yes.
to prove that
and
they've got
yeah.
a case.
And it
And
should
so-
have. It should have been. I think it typically is done within 3 days or 5 days or something. But they got an extension to the week, and then they got an extension to October, and then they vacated that extension to January. And at that point, then it was moved again into May, and now it's being moved again into July. And so,
Go ahead.
so this should have been happening, within the first week. In which case, I could personally imagine the defense would not have enough time to sort of say that unless they had potentially something exculpatory, I guess. But it was unclear if these people had even been assigned at that time. And we're still getting information that was coming in. So I think because this prosecution's witness list and evidence list had only been provided in the last week or so, the defense may not have put together a witness list beyond the key witnesses that they had retained to help with the DNA, which is no longer even going to be presented at this case. So they really don't have any witnesses beyond the witnesses that are there to say that the experts who are there to say that the potential jury pool is tainted. I think that was their other witness that already testified.
Yeah.
And this was another thing, what really cued me in almost from the start that this could be a potential op is just how quickly they moved into it, how quickly they moved into charter, how quickly because obviously if they would have gotten a grand jury indictment,
Right.
then obviously we'd be looking at the trial,
Yeah.
But they chose to just do an affidavit with all this loosey-goosey evidence that we're now finding
Yep.
out not very substantial.
Right.
Then the death penalty, right? So yeah, all that kind of cued me in that there's something.
If your evidence is that good, why didn't you show it to a jury beforehand? You know what I mean? Why didn't you use a grand jury to get this?
Yeah, they can. Now they do have normal grand jury days, like once every month or what. But I mean, they can call a grand jury anytime.
Yeah.
If they need to, right? So they could have done that fairly easily. I don't think
That's
it
why I
would
say. I mean, why? To me, it means that their shit ain't that damn. They're not that confident in their shit.
Well, and I think it's that they're trying to. The plan, again, just speculation. The plan was to try to pressure Tyler through death penalty legislation, all this other stuff, to cop a plea by now. In my opinion.
Well, and look, you know, if I was Tyler and I was able to, obviously he's not, but maybe his parents, maybe they take a browse through X every now and then. Maybe they're seeing what the public opinion is actually like, and maybe they won't let him take a plea. I mean, I don't know. If I was him, knowing I could appeal it, I mean, I would want to go to trial.
Yeah, especially if you didn't do it, right?
I mean, right now, if I did it, if I did it, that's a different animal. But
yeah,
if I was not guilty, and especially with the consequences that come with it, you know, yeah, I would definitely. I want a jury sitting there.
yeah, I agree. I mean, to me, that says just so much that he hasn't copped a plea. Just in and of itself. I mean, because you got to think about it, if you're facing death potentially and you know you did it, yeah. I just
Then
don't
you're
think
just
you
looking
would.
for a life sentence instead. I mean,
Yeah,
obviously,
Right,
some
and
people
that's
would
and
do,
that's
but-
the sort of Fed slop narrative that I think is coming down the pike. It's basically, you know, there's so much evidence. You know, look at all of the summary of evidence, and look at all of these exhibits. You know, that we may never see, but we're sort of expected to assume that they, one, exist. Or two, if we don't see them, we should believe that somebody saw them, and we can kind of have faith in the Utah government that they did this correctly.
Well,
But
so-
there's no reason to take a plea at this point, because no deal is on the table.
right.
And on the one hand, the three sort of options that are available is the death penalty, which 33% of the population in the county actually even want, along with it, you know, potentially bankrupting the county. To a sort of life in prison, and I think the third option is 25 years to life with parole. And so when
He won't get that though.
well, I mean, so the question is like, you know, what do we believe? And if you, and I guess another question is, what did Tyler actually say to his lawyers? Because if he came in and said, I did it, that's one thing, you know, whether or not he did it or not, if he's part of the op and he just said, I did it, that as I understand it, constrains what the lawyers can actually do. But on the other hand, it's just, what seems to be the case, and the strategy at the moment is sort of deny everything, make the state prove the case, and not necessarily even deny that Charlie was shot with a 30-06 from the roof of Losi, but potentially bring in doubt that your client Tyler is that person. But then the question is, okay, well, if that's the case, how do you explain these text messages? You know, was it manufactured by, you know, somebody in the police? Was it an op that you know, Tyler and Lance sort of both are in on with, you know, other people? Did it actually happen the way it went down? Did Lance potentially fabricate these messages on his computer and sort of showed this, and, you know, there's that, or you know, was it a lovers sort of true crime sex romp that is
And you know, this is not going to come up in
the
court.
NSA like tracked, and we're like, and then that was sort of the basis, and they're trying to cover it up. So,
of course, you're not going to see this in court, but I mean, there's some pretty compelling, you know, there's some pretty compelling stuff online, you know, to show that that Lance could have maybe possibly allegedly, you know, been there at UVU that day.
yeah,
You
there's
know,
enough doubt, right?
yeah. And that's why I keep going back to, okay, you know,
Which also
I
brings in
just-
the credibility of Lance as a witness too.
right, definitely, I would think. To me, though, reasonable doubt is just going to be so hard to get to, and that brings me back to, so okay, we kind of addressed that. So if they don't get the parents, if they don't end up with the parents on the stand, I think that, and even if they do, this is a point I've made. Even when Gary and others were screaming from the rooftops that they were going to testify for the prosecution, I said, yeah, they can compel them to testify, and they may do that, but they also have to put their hand on a Bible and swear to tell the truth, the whole truth, and nothing but the truth.
Yeah.
So that just because they're testifying, via being compelled by the prosecution, doesn't mean they're going to get up there and say, yes, my son admitted that he took his grandpappy's 30-06, crawled on Losi, and shot Charlie Kirk in the neck.
Yeah.
It could just be as vague as what they had written in that document.
Mm-hmm.
They may just say, we saw video. Yes, it resembled Tyler. We had concerns because of this, that, and the other, and he indicated that he might have, to me, that's not going to be a groundbreaking testimony. And then obviously with all the questions that are going to come in on the other quote unquote, confessions, I just don't see confession being a walk in the park or a slam dunk, for the prosecution.
I mean, and to the
For a
confessions.
jury, for a reasonable, objective jury.
Sure. Well, but it all requires the defense doing a good job and understanding the conspiracies, but they don't. And
Right.
so that's kind of the issue. Like, we can all sort of see, because we're privy to like all of the other, noise, what they call,
But I mean,
which
it
could all be
appears-
wrong,
right? It could be, but
But
it appears
also
that he
that's
was
not their
there.
strategy at this point. Yeah.
Right. And it appears that he was there at 6:25, and then I'm assuming this question will be answered definitively. But I feel like if he was there at 6:25 on the 11th, that he would have been Mirandized, and he would have had his phone taken. Gary's whole argument is, and I think the first time I heard him actually say that was when you were debating him that day. But he was like, no, they made him comfortable, and he would have probably had his phone. I mean, why would they take that stuff, and sit there that whole time without, and I was like, oh my God.
Gary needs to go to jail for a week. Then you go put
Yeah,
Gary in
yeah.
jail for a week. That way he can experience it firsthand how it operates.
Right.
Right.
Yeah,
Yeah.
yeah.
And I think the argument there is it's ambiguous whether Tyler was Mirandized or that conversation that's in that document took place on the 11th or the 12th.
Yeah.
If it's taking place on and either way, this has to do with who he's talking to first. There's a question of, did they leave him there for a couple of hours, by himself with his parents? If they didn't arrest him because he had come in on his own accord and they were just sort of talking with him, did he say anything? Like, when did he actually allegedly send these Discord
Well,
messages?
that's the
that also
thing. They were
constitute
supposed to be
another-
sent at like 9:00 at night, I believe, on the 11th was when that was supposedly happened. So, I mean, if he was Mirandized and they did in fact take his phone, which I don't see, look, I don't have a lot of experience, but the little bit experience I've had at jail, I didn't have my phone from the time I got to the door until this is all over and done with. And again, I'll make the same dumb point, but to me it seems so obvious. If they didn't Mirandize him and they stuck him in a room, he kicks back on the couch, he falls to sleep, starts snoring, and is like, oh, I did it. They got it recorded. Oh shit, we didn't Mirandize him. We can't use that in court. I mean, just like it makes zero sense.
Here's the thing, right? We're coming up with like problems in the court, right? But this is all, of course, recorded, and potentially the defense or the prosecution could be watching this and taking notes, and then retroactively creating stories that explain, and sort of explain away this problem in ways that cover their asses, and then produce something that we're given that lets us say, oh, okay, well, because it's written in this document, well, now we know, right?
Right.
But all of this is potentially, if the op is flexible enough and it's responsive to the critiques and the concerns, then it's this like constantly evolving thing where more explanations on top of more explanations are added, and in order to sort of protect
a lot of amendments,
kind of like a
going on.
pyramid scheme. You know what I mean? Where you gotta,
Exactly,
keep covering up
exactly.
this- let me say this. I think, just my opinion, I think the people behind the op have such control over the media and right now also in politics that I think that they were kind of lapsadaisical with putting all this together and just kind of, again, trying to lean back on, well, we can just get him to cop a plea and we'll be done with this and everybody can move on,
Yep.
Yeah. The other thing is, in order to like make people feel good about this, it would have to be compartmentalized to such a degree that you couldn't necessarily, like, all of it, like Jeffrey Gray couldn't know that people were lying, right? And Brian, what's his face?
That's the thing. Yeah, people always want to say it's too many people involved, but if you keep it compartmentalized, I mean.
Right. So Jeffrey Gray can rely on Brian Davis. Brian Davis can rely on the SBI. The SBI, the State Bureau of Investigation, can rely on Mike Mitchell. Mike Mitchell can rely on the parents. The parents can rely on the on Tyler. And the only person who needs to know what is going on is potentially either Tyler or Mike Mitchell, or like somewhere in that chain, who can create the degree of plausible deniability for the other people so that they can, have plausible deniability or just don't know, and sort of, keep this going, not knowing or not knowing that the evidence isn't necessarily there, but sort of being of the opinion that there's enough evidence, according to one of their people under them, that they can feel good about believing that the case has merit. If that makes sense.
Go ahead, Echo.
It's sad that you got to say that.
let me say this. This is going to be one thing for me too that I'm going to be looking out for that could potentially indicate op, and that's whether the defense files a motion to seek redress for the paving over of the crime scene. Obviously, that
I don't think anybody's going to mention those pavers.
Well, because the thing is that on top of the kind of lack of evidence from the state, they could at the very least get like an adverse jury inference or some other, quite frankly, I think there's enough to dismiss the case on that alone. Just
I think there's enough. Yeah.
But
you would
even
have
a
to have
penalty would be advantageous, everything you can get. So I'm going to be looking out for that.
Yeah, but the thing is, if it's as controlled as some of us are sort of assuming, then even if there was enough evidence if there was not enough evidence to dismiss the case, they just wouldn't anyway, because there's that. The other thing is that I guess the only way you need to do a crime scene reconstruction is if it is a death penalty case. Mm-hmm. And so if you take off the table the death penalty, then you no longer, if I understand what they were saying correctly, then you no longer need to do that crime scene reconstruction, in which case it doesn't matter that the crime scene was paved over, because it may not be a death penalty case anymore, in which case that would not necessarily matter. That is sort of what one of the inferences I picked up from
Yeah.
what was being argued there.
Yeah,
Maybe a little bit of bullshit, but yeah, I mean that's the whole idea, you know. Hey, look, I'm going off camera. I'm just going to swap my batteries, so I'm
You're good, bro.
here, but you know, I'm swapping my batteries real quick. So y'all continue on.
Yeah,
Sure.
with the death penalty thing, and so in Utah, obviously it'd be a due process. Tyler would say my right to due process has been violated by the destruction of evidence, and in Utah, it's essentially a two-phase inquiry. First, Tyler would have to show a reasonable probability that the evidence that was destroyed would have been exculpatory. Or not would, but have a reasonable probability that it would have been. And then it essentially flips over to the state to provide the reason why it was destroyed. And then based upon the strength of other evidence, then judge kind of determines whether destroying that evidence really materially affected his defense. And I mean, in this case, with the inconclusive bullet fragment, I mean, wouldn't you assume at that point that if there were going to be other bullet fragments, it probably would have been in and around where Charlie was? Again, just kind of playing this argument in my head. But I mean, every which way I've done it, I think there's again, just judging by the case law in the Utah Constitution, I mean, I think there's a great case to be made to, again, at least get an adverse jury inference.
Totally. But you wouldn't be able to make that case if it stopped being a death penalty case.
Okay. Because of the crime scene. Well, let me ask you this, though. Obviously, paving over the crime scene allowed them not to do the crime scene reconstruction, but what about actually collecting like forensic stuff? Because I don't know the answer to this question, but like, what about, is there a difference between crime scene reconstruction and crime scene evidence collection as far as like other bullet fragments, stuff like that?
Yeah, I mean, I assume there is, and I can also assume that
Don't forget microphone pieces.
Yeah, right. Well, but so that is true, and I can imagine the feds or whoever would do exactly what they did before, which is like, oh, it's inconclusive, but it's consistent in certain ways, and so therefore, and I joke about consistency because they're basically saying like black clothes and dark clothes are consistent, or white shoes and light shoes are consistent.
Consistent
or like the
with, exactly.
is consistent, right?
But like, they're not the same. They're different.
Right,
I mean,
exactly. But you can sort of
the language is
overlook the sort of differentiation that would happen if you just sort of do consistent. And this was the thing about like Butler, for instance, like the direction of the sound was consistent with the shooter's location, but it was also, I believe it was consistent with the local sniper team as well. So it's like, okay, we'll just leave that one out.
They did though. Trust me, they worded that thing very carefully.
Exactly. So if you've got the FBI who's sort of in charge of the investigation, who is figuring out what evidence to collect, what evidence to not collect, how long the investigation is going to go, like when to shut it down, what to who to tell. There's a lot of ways and this is, I mean, what does this say about the criminal justice system or the law enforcement process, that you can sort of finagle this the way you want. You can plant whatever evidence you need. You can sort of throw down this blue wall of silence and sort of ensure that everybody says what they need to in order to make it do whatever. So there's a whole lot of problems, and the courtroom itself, which is restricted based on time and money and resources, etc. You're not necessarily going to get the truth in that. There's how many people have been convicted only to later be found to.
It happens all the. Let me tell you something real quick while we're on this point, and this is especially true in federal court, especially true in drug cases. The laws are so punitive that most of the time, and even the defense lawyers like force. I mean, I say force, but like heavily suggest people take pleas, and the government, and again, this is my experience in federal court anyways, that the federal government has not been challenged so many times that now they cut corners. And I'll tell you, it just in a few drug cases I've done in federal court, I've never litigated a drug case in federal court where the actual test was correct. You know what I mean? Because they just cut corners. They just make up numbers, all that stuff. And so, yes, these things are real. And again, these people who might otherwise be able to successfully challenge and maybe get found not guilty or lesser ground, like their lawyers are not helping them do that, right? The whole system is so tilted against defendants. It's sickening.
Yeah. The other thing is that more and more, and Kash Patel just sort of launched an entire program on this, I guess. Law enforcement is using AI to. Oh, did he just leave?
Me? No, I'm here.
No. Our other friend.
Where did he go?
I think
He might have just knocked something loose.
Yeah, he had a problematic connection.
I had my settings up. That's why I asked if it was me, because I didn't actually see him drop out.
Yeah, I'm sure he'll be back.
Yeah. There he is.
Hey.
Hey. Oh, we got y'all out of order now. Now you got to look the other way when you're talking to.
Yeah. What I was going to say, Greg, was that more and more police have been using AI to help them with their reports.
Yes.
And I think in some places it's illegal, but may still be done. And on the other hand, it's not illegal in other places. I don't know what Utah is like there, but if you've got these hallucinations, AI hallucinations, if you got it, if you're just sort of filling, I mean, and I don't know how they would do it, but if you are putting in bullet points and say, create a affidavit of probable cause with this, there's some problems there, of course, and you also saw, the Washington Sheriff's Office literally putting out AI-enhanced pictures.
It admitted it in the media. Oh yeah, these have been AI.
Yeah, and just putting it on their Facebook and saying like, "We're looking for this person," and people are like, "That's AI, bro."
Yeah.
And it's potentially there to prevent people from seeing the actual person, so that they can, have the days of delay that they need to put together their story. And the media was also doing AI enhanced videos with the shooter on the roof, from the sort of from the left, that was based on this other video where the two people were like, "Oh, somebody just ran from there to there," saying. But it's like, okay, cool. We don't have a source on that. We don't have timestamps on that. We don't have a chain of custody on that. It just got posted to social media, and now police are potentially going to be using that information.
Social media,
yeah. And so, what is to stop TPUSA potentially from having somebody all in black run up there, take a little video of it, post it to the media, and then the rest of TPUSA does this.
And
thing.
Of course, we have police reports or dispatch calls describing somebody that almost to the T matches Lance and not Tyler.
That's the only authentic piece of evidence I think I've heard in this case was actual calls.
Well, the other thing was that there were multiple sound recordings that were saying different things, and some of the sources for those were just kind of it was just again just on social media. And it was also claimed that this might be AI generated voice calls as well, right? So
I don't think they should be able to use anything from social media. That's just my
But
opinion.
yeah, exactly.
I mean,
And,
if you take
but-
somebody's phone and get it from their phone or what have you, if there's a way, but yes,
But that's what I wonder. So, like, is this an op in order to overlook the lack of chain of custody, and instead admit and normalize the sort of, taking things off of social media as a way to make this happen? If anybody, I just got turned on to this show by somebody. It's like on BBC. It's called The Capture. And what it is it seems to be, and I'm only a couple episodes in, I should say, but it's CCTV that is sort of seems to be using AI to show people doing things that they didn't actually do.
Right.
And,
That's some
and
scary shit.
trapping them to do that. But that's the same thing of, like, potentially the videos that were in the White House Correspondents' Dinner
Right.
or event. This was potentially the Bondi thing in Australia. This was potentially the Brown.
There was the dude at the picnic table getting his makeup done.
Right, yeah, right. And then also, like, in the Iran war, right? Israel has been shown to be doing some of these as well. And I should say all of those media, whether it's Daily Mail or New York Post or whatever, are also very friendly to our greatest allies.
Oh God, of course.
It's and you got Bibi who's coming out making claims immediately after. You've got Trump who's also saying, like, we got him, and also
that's the kind of thing you don't touch unless you absolutely have to. You know what I mean? Stupid PR move to bring it up.
Right, but again, that's media is going to report on that uncritically just because it's what the president said. And so you don't even need verification because it's assumed here. And so like that's kind of the nature of the brave new world that, we're operating in. and if we're moving to a place where there's more and more political opposition to the powers that be, and those powers that be need to find ways to either lock people up or whatever. On the one hand, you've got NSPM 7, which can target everybody. On the one hand,
we're all terrorists.
But also if now, like, you now make up something that did he leave again?
No, that was my bad there. I accidentally whoops. Sorry guys, I hit a button.
You need to tighten up, Adam. Tighten up.
I was trying to type in the chat. Go ahead.
Same thing I did.
Anyway, so the point is, if you've got NSPM 7 on the one hand, if you're capable of sort of fabricating these events through AI, social media, and I wonder personally if the video of the guy running on the roof and jumping off is AI.
Yeah.
If that's in the realm of possibility, but you also like can't distinguish it, and then when you do distinguish it, but you're like, there's something wrong, but I can't tell what. And somebody's like, well, you have to like tell, like, you don't have any proof that this is AI, and it's like, well, like, I can see it and it looks wrong, but it becomes a way to even potentially, and I think the White House Correspondents' shooter, or maybe it was somebody else, and you've also got Luigi Mangione, all of these different cases that have problems, where cameras are being turned off and guns are found, in
cameras
places
never work.
Right. Yeah, exactly. The point being that, like, all of a sudden now, if you're a conspiracy theorist, that might be an indicator for, you being radicalized, and now you can be on this list. And now anybody who doesn't buy this Fed slop is a potential terrorist because, they're
I don't like the road you're going down.
right. Especially if we are now told like we are going to have boots on the ground in Iran. We're going to be, potentially doing all of this thing.
Well, I like
And-
Charlie Kirk being the reason for all this, even though it sucks what happened to him. I mean, but I prefer that and maybe the Iran war being the catalyst and the whole reason for this than the theory you're talking about, which is absolutely possible. I mean, yeah, absolutely.
Yeah, I mean, and the trans thing is a hot button issue in politics.
Let me say this too: is that they keep saying, "Oh, they were furries." I haven't really seen too much evidence of that. I mean,
I seen him in a
pictures
freaking hoodie that had some ears on it,
like an animal hoodie, but
yeah,
I
it was
haven't
just a
seen-
hoodie with ears.
If I understand this correctly, it's one because of the hoodie, two because of the engravings that say like "notices bulge," which is, like connected.
Yep.
But I also think like the Daily Mail or New York Post or something had like a deep dive where they like allegedly found, and it's unclear how they found this, the specific social media accounts that allowed them to say Lance might have been in a group that might have been related. But then also I think there was a comment, and I don't remember where this was. Somebody had like a furry, like a bed in the apartment that was like a furry thing, but that got removed by the FBI in order to like downplay this, so like
like they're trying to downplay.
Yeah, exactly. It's rumors. It's tabloid.
Correct me if I'm wrong, but not one single time in any of the official documents that have come out does it state that Lance was directly affiliated or even specifically himself being trans, right? I mean, as far as I know.
The trans thing, it says... and it was.
I mean, there's pictures of him in makeup and stuff like that. So I mean, I guess he was cross-dressing or
Yeah.
I mean, again, no concern of mine. But like the furry thing just seems a stretch to me.
That's why I say I don't remember anything specifically saying that he was that.
And I've said
it brings
that was
up
one of the main things that clued me into this possibly being
it was
a psyop. And it was
me
immediately
for sure.
I said, they are pushing this furry narrative so hard.
Look, how many shooters were that, and they will not touch it with a 10-foot pole. They'll do everything they can to avoid even saying that it's a trans person that shot the place up. But for some reason, this time, right off the bat, before his body was even cold, they were saying that it was trans related, so that made me realize there was something going on.
Yeah.
Well, on the one hand, if we're talking about like fake events, I would also wonder if those other events might have more to it than that. I do think that in the criminal information document, they do say his roommate, a biological male who's I think doing transition. So I think that's where the trans that's the first place that the trans comment comes up. And the only other thing is they do have the inscriptions on the fired casing reads "notices bulge," and they misspell it in the two different documents. And I think they even, I don't know how you spell uwu, to be honest, but I thought it was UWU, not OWU.
Yeah, I don't know if that's misspelled or not.
Right. So that was the furry thing, but that's, at least let me rephrase, that's the closest thing to the furry thing.
Yeah.
And then people took that and sort of ran with it.
Yeah, because it's so easy to get people like upset in their feeling, and like to get them like not liking them,
especially
after we just gotta execute the furries anyways. Who cares?
Look, especially with the history we had over the past few years with trans shooting, and then of course, conveniently, that's exactly what he's talking about whenever this happens. So yes. Definitely.
But again, these events are like the perfect political enemy of
Oh,
the people
what? Exactly.
who are potentially manufacturing these ops. And I
I
think
did
you
it
just,
again. Sorry.
you did it again.
My wrist keeps hitting the pad.
No worries. So anyway, so if that's the case, and it might be the same thing as what happened in Israel on 10/7 or whatever,
Mhm.
where you have a potential controlled op who I think there's been evidence to suggest that Bibi's been funding Hamas
Yes.
as a way to kind of destabilize the region and also give a reason, to attack them.
Yeah, that allows him to cut the grass every few years.
Exactly. So you have a controlled op who can, do terrorism whenever you need it to, which then 100% justifies the response, which can then be the political cover you need to put things like the NSPM7 on the one hand, or cut the grass to the level that is getting to ethnic cleansing, getting to genocide, getting to greater Israel, getting to war with Iran, and you have and you also have the potential to narrative framing to say, like, MAGA or conservatives or Trump is under attack by an insurrectionary group, and so therefore we're going to bring in this Insurrection Act in order to address the issue.
What you call that is oh Lord, I can hear it. It's going through my head just perfectly saying it. I'm not even gonna try dialectic. I can say that part of it.
Hegelian dialectic.
Hegelian dialectic. God, I couldn't get it out. So hey, you caused the problem, and then you got the solution. Just kind of like the COVID. I mean, we could go down a long list of those.
Hitler was doing that.
Right?
The Reichstag flag. You've got this. I mean, it's just the blueprint of a false flag, which seems to have been activated in potentially multiple examples.
Yeah.
And whether they're all ops, I think there's a case to be made, but it's a fascinating
out of chaos.
Yeah, it's a shock doctrine, like whatever you want to call it. It's where we're at right now, and whether we believe
for you, buddy. So you said you're smart.
Thank you, Jen.
Echo. I hope you join us more. I'm really enjoying this stream.
Oh yeah, yeah.
I
knew we'd have a good time.
Yeah.
There's a lot of people making comments in the space, and there's not a lot of people who are lawyers. And so, you've got
the ones that are all hacks in one direction or the other.
Well, you've got and so you've got Andrea Burkhart, who I
she's not bad, but
she's not bad, but she's she
goes on Gary's show, so
she's been on Gary's show. She's been on Jack Posobiec's show.
Yeah.
She was with Colvette and Blake Neff, right?
Yeah,
so she's and she is open to a conspiracy if it includes Lance or the people on Discord, but any other conspiracy she's sort of not with, right? And on the other hand, you've got Baron Coleman, right, who's a little closer to, very close to Candace, right? And so you could potentially, if you're of the opinion, and I think Blake Bednarz was sort of calling her a trolled op. So
one point I want to make about that is, he was saying
Blake Dog, but you've also got Entheogen Esquire. So I appreciate.
He's perfect. I mean, he's not affiliated with those. He may agree on certain points with what but he's not affiliated. Yeah.
Is that a teddy bear there, Greg?
Yeah, that's Buddy Bear.
I do comedy with Buddy Bear, so like I've been kind of integrating him into all my content.
I love it. Yeah,
my best friend, man, is a Buddy Bear.
Yeah,
bring him back into the frame. He's a good guy. Yeah. Anyway, I appreciate that.
And I'll
Yeah.
say this. I mean, just I think Barron is very intelligent, very good lawyer, obviously a very good investigator. Like, he's, in my opinion, is the whole nexus of content creators on this issue. I
He
think
is
he's
one of the best all around.
He's one of the best.
And yes, you may not agree with everything he says, but at the end of the day, I think, yes, the combination of the research that he does, but very much the delivery. I mean, he's got a good show and popular for good reason.
Mm-hmm.
Like I said, you may not agree with everything he says, and I don't agree 100% with anybody, but all around though, I mean, like, I can see why he has gotten so popular. And he's, according to Gary, one of the most dangerous people in the business. So
Well, I think we could all sort of increase our level of danger.
right.
I think
Yeah.
it's going to be necessary to, threaten the stability of this op if we want to. Yeah, I mean, and it was funny. This is the preliminary trial is going to be like 2 days after the 250th anniversary of the
Right.
United States Declaration of Independence, right? So there's some symbolism going on here, along with the 33. Both the 33 hours on the one hand, and then I was looking at this case, and it from the time that they have Tyler walking onto campus to the time that he takes the shot is 33 minutes.
33 minutes, yeah.
Yeah.
So it's
And
you
then
got a whole lot of-
33% of the people, like you were
right,
talking about
right,
earlier.
yeah, exactly.
Man, the coincidences are just so
Yeah, well, I
unbelievable.
think we got to start talking about the conspiracy where everything's like a holographic simulation.
Well,
'cause
look, I've got a
it's,
book on symbolism, and
Mhm.
and I would like to one of these days. I want to, and I'd like to find somebody that is really, really like has been into that very deeply, the whole symbolism and the numbers. But yes, I'm definitely planning on doing a show at some point in the future because it's interesting to me, and this is what I always tell people. You know, you may roll your eyes when I start bringing up all
Yeah.
these things about the numbers, and that's fine. You may not believe in that kind of thing. You may not agree with that kind of thing. That's also fine. But what you do have to realize is they do.
yeah.
And that's
Yeah.
all that matters is they believe in it and they do. And so, yeah.
I'll just plug. I did my my graduate degrees in philosophy and religious studies. So,
Oh, I love it, dude. Yeah, we definitely
you
need
go.
to
I'm all
talk.
about
Yeah, we need to
the
talk because I'm
symbolism.
an expert.
There you go.
religion, too, so.
Well, we'll do
Yeah.
another collab on that
Yeah,
on
man.
that subject.
And in terms of entheogenic stuff, I was looking at the Native American Church in Utah in particular, and you have the Native American Church on the one hand, and then you've got the Native American Church of North America on the other hand, and those
Okay.
two churches were competing to figure out who could basically monopolize the peyote tradition.
Well, in
so to speak.
ONAC too, they have a whole bunch of sacraments that they've expanded into.
Yeah, but the issue was that the Native American Church of North America, as I understand this, and I'm drawing on an interview I did with James Flaming Eagle Mooney.
Yep. No, yep.
He was basically saying that they wanted to put him in prison for life and only allow for people of indigenous descent to have access to peyote, and the prosecutor, the judge, the governor, the attorney general, I think, who were all LDS and were all kind of potentially. If they don't do what the church says necessarily, they get excommunicated. There's, everybody's giving, whatever to the church. So point is, they all sort of colluded against him, arrested him, put him, basically try to put him in prison for the rest of his life. And I think he I don't know if he went to the Supreme Court or it got settled out of court, but they found that these Utah officials had engaged in a criminal conspiracy to violate his rights,
Yeah.
and eventually it got dropped. But if we're wondering about the Utah officials here being capable of a conspiracy, I mean, there you go. Right?
There you
So-
go.
It's funny you say that because there was a mushroom church called Singularism that just won their right to commune under Utah state law in the federal court, right? So they took it out of the state court and gave it to the federal court. And it's like, yeah, it's funny because the federal court says now we really get to see how committed to religious freedom that Utah is, So yeah, that's a great point and a common theme that's been, going through these cases.
The other thing I wondered about it was the Native American Church is the only church that is recognized by the United States government. There
is a statute on point. Other religions have been recognized through the courts, but Congress pressured the DEA back, I think, in the 80s or 70s, 60s, to pass a specific statute that makes exemption from the federal laws for the Native American church. So in that way, yes, they have, Congress has officially recognized it.
Well, I mean, and I was just wondering, I wonder how the Church of Latter-day Saints might feel about that, and with all of this questions about miracles and
Adam Smith might have been taking the sacred mushrooms, huh?
Oh, don't you know it?
Joseph Smith, but yeah,
Joseph Smith. I knew what you meant.
but just in terms of LDS affiliated people being able to enshrine their particular perspective into law, I wondered if there were some sort of Mormon aligned ideologies that were maybe coming in here, and if this was a conspiracy to dead name Tyler or dead name Lamb, and Miss Twigs, according to the defense.
Yeah, so I thought once I started, or at least in my heart of hearts, feel like this was a for sure psyop with our greatest ally over there.
Yes.
And then Barron obviously did some Google searches, search trend. So I went and looked up, and in February of 2025, people in our greatest ally were Google searching Utah County District Attorney's Office because I thought, if you're going to do something this far reaching and involve a crime, well, obviously the DA's office is going to be probably your first stop to get on board to be able to do this.
Yeah, for sure.
Yeah, I mean, it shows that those people there, and again, I'm not being discriminatory, and they're like, yeah, I think that they are prone to be able to engage in mass deception.
And so on the Google thing,
Right.
there's, I hate to keep bringing him up, but Gary Melton has been so against that, and he talks about how you can't repeat. It's not repeatable, not consistent. It's just basically a toy that it's not any kind of dependable, reliable tool, and blah 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 blah. The whole purpose of it is for like these big corporations and
Business
stuff, marketing
research.
places. Yes,
That's how
so they
Barron
can.
learned it.
Yep. That's how he knew about it. But so they can see what the trends are.
Yeah, but the it not being replicable is not an argument against it, because it couldn't be, because as soon as you're doing
They deleted
it. Well, as soon as you share that with people and then they all do it, then the numbers are all going to change.
True.
So,
But one of the big arguments against it, though, and what I was going to say though is, he's claiming how it's not a useful tool, and I always bring up the fact that Nancy Guthrie, I know Megyn Kelly reported on it, but talked about how that the police used Google Trends in that investigation.
Yeah.
And so he doesn't ever bring that up. But what what was the other thing I was going to say? I'm pulling a U now, and I lost what I I don't know.
Well,
It'll come
I'll-
back to me.
Yeah, I can, just in terms of the Israel-U.S.
Oh, I remember now. No, what I was going to say though was,
As soon as I say Israel, right?
as soon as you said Israel, but one of the big things I've always heard against it though, people say, that is just stupid. Here you are saying that the FBI, United States government, and by saying Huntsville and our government by showing D.C. and possibly Mossad or whatever in Israel, you're alleging that these people are the ones that are doing the searches, and that makes no sense because there's all of these classified and secret ways they could do it without Googling it, where it wouldn't show up on a Google Trend search, and that is true. But what if these are rogue elements of all of these institutions and entities, and maybe they don't want, maybe they don't want people above them to know that they're involved in such a thing, and maybe it's safer for them to do it on Google than to have the possibility of some kind of repercussions for it later because they've done it, because if you did it on one of their searches or what have you, that it's going to be right there. Anybody will see that, can see that. So I don't know.
Yeah.
That's one thing I've always thought is, maybe it's safer to use Google than to use the official, the official ways if it is just a rogue part of the FBI and a rogue part of,
Yeah, I mean, and I think back to on the one hand, and Trump sort of working with all of these like major tech groups. On the one hand, you've got JD Vance's relationship to Thiel, his
Palantir.
relationship to Palantir, right? And you've got Elon Musk sitting next to Trump, at the Charlie Memorial. So, when I think to U.S. Israel intelligence joint operations, and I think of something as complicated as Stuxnet, where they were needing to put together the cell phone or the pager bombs or something.
Mm-hmm.
You're working with a lot of people to keep something secret, right?
Mm-hmm.
And you've got military involved here. You've got UVU, which is very connected to that military, both as a sort of feeder of students into NSA, into CIA.
Yes, that is a really big intelligence,
the different competitions that UVU students are number one in. And so it just strikes me that and the person leading George Zinn out, I think, was literally like UVU student who was also like National Guard or something. The UVU police chief Long, and the person who hired him, who was the facilities person, who's also on the board. We're both
the connections are endless.
BYU and National Guard or ex-military or whatever. So, not and not to say that this implicates them, but it does suggest if you are looking for motive, capability, opportunity, right? All of that, this would be the perfect place to do it. And so, add that to all of the other weirdness, and you can start seeing how it is an op on a whole nother level.
Yeah.
Yes. And yes. And it's just amazing when you start looking for all these little, connections and stuff. That's why you have such, there's some really good researchers out there that have been, neck deep in this from day one, and it doesn't end.
Yeah. It's, it'll be, it's going to be good. I mean, and I hope this happens when we really do figure out exactly what happened. Right. And hey, again, God bless Candace and Barron, and I guess all of us to the extent that we're helping out on that. But it's like, just imagine if they weren't doing that, dude.
Oh God.
we'd be stuck with Tyler Robinson narrative, regardless
Yeah.
Of how legitimate we thought that it was.
I think
you know?
I think by
and-
now they'd have had him hung in the streets. You know what I mean? Really, kind of like that one guy on oh, what was it on Newsmax? I can't remember his name. He was
Oh, you're talking about Brian, or no?
no, not Brian Enton. He's on Newsmax, and he was Andrew Colvett was on his show, and he was talking about how they had been talking privately, and he was talking about how he'd like to just or something like that, you know, and talking about the conversation that he can't say on the air, and
Yeah.
you know how we used to just do you know what out in the streets, and yeah.
Yeah, and I mean it speaks to the sort of assault on the judicial process that serves certain people's interests, but maybe not everybody's.
Yeah,
in my
definitely two. You can call it a 2-tier system of justice, a 3-tier,
Oh, there,
whatever.
yeah.
But it's definitely more than one. I mean,
Yeah.
you know,
Yeah, I've had to work in it directly, man. It's terrible.
yeah, it's crazy.
It's terrible.
Yep, crazy. Well, y'all wanna call it there? I know it's been pretty long.
Yeah,
Seems
brother,
like
I'm kind
I'm
of
seeing an awful lot of good
now.
nights in the chat. So
I enjoyed this.
Oh, yeah,
Echo,
me too.
I gave you my email and stuff, man. Just shoot me an email, and I hope we can
Sure.
do this more often, man. I really enjoy it. And I'm still catching up on a lot of the pleadings, but over the next week or two, I'm going to completely catch up on the record there. Like maybe we can do another one and go a little bit more in depth on some of this stuff. if you
shoot
want
ya.
to.
Yep,
Well,
we can do it.
shoot, I hear May 19th is the next thing that's on.
Yeah,
the,
maybe we can meet up for
thing,
that,
so-
or do like a post commentary if y'all want
Yeah,
to.
yeah, absolutely. I seen a bunch of best show ever in the chat too. So
Yeah, it's because Echo's a badass.
yeah, that's right. He's smart.
Appreciate
That's what
it.
Jen
Yeah,
said.
he's-
Hey, it's when you got good interlocutors, you're it's not even you that needs to do
It helps, you know. Yeah.
That's right. That's right. And you know what? I meant to. I probably didn't. I'll have to go back and double check. If it's not his ex account will be in the description of the video, and Greg's. I'll put Greg's in there too. I'm so bad at those descriptions. I've got to start doing that stuff ahead of time.
No worries. Yeah, ecological crime on X, and
Yep. You can also look it up. Yep, that way, ecological crime on X. Anybody that has not subscribed to this YouTube channel, please do that. And also, to
Yeah,
Greg.
please subscribe to Adams for sure.
So close to getting monetized. I think.
Where are you at
last,
right now?
Last I looked, I think I'm at 440 something, 444. So I've got to get to 500, and then all I'll lack is a few watch hours. Yep. Yep,
Nice.
you got to have 500 subs and 3,000 watch hours. I'm at 444, and I think I've got right at 2,000 watch hours. So
Okay.
anyway, we're
Sweet.
getting there.
Cool.
We are getting there. And yeah, anybody that wants to contribute until I'm monetized, I know my pay links are pinned at the top of the chat. They're also in the description. Yeah, I appreciate everybody coming out. That was a lot of fun.
Yeah, I enjoyed it, man. I really did.
I hope everybody got something out of it. It kind of sounded like they did. So, yep. And we're more than happy to do this collab again here real soon.
Yeah, man. Hey, and I did the screen recording. If it doesn't record, Adam, y'all just let me know, and I can share the screen recording.
Okay. All right. Well, sounds good, guys. I had a ball. I'm glad we got to do it. Too
Yeah.
bad Matt wasn't able to pop in. Matt, sorry, buddy. Hey, we missed you.
He'll get us next time.
Yeah, have to get us next time. So, anyway, somebody just answered my question. It's 4:43. All right. Well, some of y'all in the chat, jump in there and hit the subscribe button if you hadn't already.
Yeah, thank y'all.
All right, guys. Like I said, it was fun. It was good. It was fun, and it was real fun. So,
That's right.
all right. Well, yeah. Till next time.
God
See
bless
y'all guys.
Your weekend.
Y'all have a good one. Y'all have a good weekend. Good night.
Will do. God bless y'all. See ya.